So Ros, we touched on international in a previous bite, and we talked about it from a should you go, when should you go. But let's drill in. We talked about financials and legals, that we'd come back to them. So let's talk about the legals today. We're in an unregulated environment. We work to the BFA standards, but that can all change when you go internationally. And from a legal point of view, there's lots of changes. Should we drill in some of that today?
Yeah. Once you're well established as a franchisor in your home market, let's say for the sake of argument that's the UK, it's very tempting and it can be commercially extremely worthwhile to look at developing your brand internationally. Just covering the legal structures around this for now. This is where franchising can become complicated, and you have to allow for a cost and time for a process. As you say, the UK is largely unregulated when it comes to franchising. You can rely simply on the contractual terms in the franchise agreement. Overseas, it may not, depending from one country to another, it may not work that way. A number of other countries are more regulated insofar as there may be mandatory disclosure requirements, which is a process that has to be followed before you can even offer a franchise. That brings in the requirement to create a franchise disclosure document. Some countries also will have a requirement for registration. So you will have to register locally in order to be able to set up a franchise. And regardless of what you say about the jurisdiction, that is the law that applies to the franchise agreement, I'll come back to that in a moment, it is always going to be necessary to get your agreement checked out by a lawyer locally. The most logical and probably the most cost-effective thing to do is to have your agreement drafted and written in the UK, because your UK lawyer should understand your business. But that then necessarily has to go to a lawyer locally who will be able to review it and advise on whether there are any local laws that impact on it. That is whether or not you choose for English law to be the jurisdiction or another. There's a whole set of different considerations around that. Suffice to say, for the purposes of right now, in an ideal world, if you are a UK franchisor, you probably want your agreement to be subject to English law. But when it comes to dealing with people who are going to take on a master franchise, you're dealing with people with established businesses already. They may well negotiate and insist on having their own local jurisdiction applying. And you're also going to have to think quite carefully about what you do about arbitration and mediation. So you're going to have to agree some kind of structure around what happens if there's a dispute between the parties. So there's quite a lot to think about. The disclosure process, apart from anything else, can take quite a while. And in some countries it has to follow a specified format.
And can be very detailed. I've done these before.
And can be very detailed. So this is one of these things. The potential benefits to a franchisor in opening internationally can be quite considerable. But even leaving aside all of the commercial costs, which you'll cover on a separate bite, the legal costs can be considerable. You wouldn't want to be even thinking about trying to do it for less than £20,000. And to be quite honest, depending on what countries you're talking about, the fees that you incur can actually be a lot more than that. The other thing you have to think about legally is the protection of your trademarks. I always say to franchisors, as soon as you start thinking about franchising overseas, as soon as you start even the vaguest discussion with people, you must register your trademark for that territory before negotiations are underway. That's an unpalatable thing to say to some franchisors, because they say, well, I don't know if I've got the deal yet. And I don't know whether I'm going to receive all the money that I'm hoping, and I need to pay for it out of that. Yeah, but the danger to you in proceeding with negotiations without having registered your trademark can be huge. Because what tends to happen in some cases is that the people you're negotiating with decide as a favour to you to register your brand name in their name.
And I have seen that happen
And
on numerous occasions.
We have all seen that happen on numerous occasions.
Yes.
So the chances of getting it back afterwards can be slim to nil.
Yes, yeah. And on not having it trademarked at all in the UK before they've gone and realised that as well, which is probably another conversation for another day.
Which is indeed another problem, yes.
Yeah, okay. Thanks very much.